I feel like I have courage and can speak out is because David, he's like, why don't people just say how they feel? And why can't, what's hard about a conversation? He didn't understand what could be hard about a conversation. He just, if you have to say it, then say it. I'm like, oh my gosh. I know. I agree.
All right, my friends, besties, it's Katie Joy. We've got to talk about Ysabel Brown and her lawsuit that's happening in Utah. And some of you are confused about why we would cover court cases of reality show people, because that's what we do on this channel. And we cover all things sister wives, whether legal or not legal, of the people on the show. I covered a lawsuit where Mr. Peyton Brown was sued by 2 women in Nevada. And in this case, it's no different. But in the case of Ysabel Brown, this case is related to an accident that happened a couple of years ago. So there's a kind of some suspicion here with some of you in comments that this might not be on the up and up, and you weren't sure how you felt about it, and if this person suing them might have eyes out for money because they know that perhaps Ysabel's mom is on a reality show. But regardless, Ysabel was required under the law to respond to the lawsuit, and she has, and she's fighting back. And she's actually requesting a jury trial here. So this is good, I guess. The one thing you can say is when you are sued, hire a lawyer and get help, right? And that's exactly what Ysabel did. Now, if you recall, she's being sued in the state of Utah, and the woman suing her claims that a couple years ago, they were driving on a stretch of highway that's extremely busy. And Ysabel, she alleged, was driving too fast and too close to the person in front of her. And as traffic came to a stop during rush hour, Ysabel ended up rear-ending or hitting the person in front of her. And then this person claims then that person hit this other person and this other person hit her. So it was like a chain reaction of a accident, which can happen. And she was claiming that she had suffered all kinds of damages and that she had lost enjoyment in life. And it was, some of you were like very sympathetic, thinking that this was all crap because it happened a couple years ago. And others of you were like, no, Ysabel needs to be responsible if this actually occurred. So she hired an attorney, and her attorneys are saying that her first defense is that the complaint fails to state a claim upon which can be granted. So she's not doing a motion to dismiss. Her second defense is answering the specific allegations of plaintiff's complaint. Defendant admits, denies, and alleges as follows. So she does admit to some of this, and then other parts of this she doesn't. She denies, or she can't state if it's true or not. So Ysabel admits that she had a driver's license when this happened. She had completed driver's education. She was aware of the safety laws, and she was driving a car on the I-15, and the other plaintiff was driving on the same road at the same time. But she denies these aspects. So she says that 11 and 13, it says directly behind plaintiff vehicle was a vehicle operated by Matthias Viragginato. Positioned directly behind them was someone named Jawat Marai, and defendant was operating an Honda HR-V directly behind Mr. Marai's vehicle. And Ysabel denies that part. So I don't know what she denies. She just doesn't know, or if those people weren't involved. I don't know. And then she couldn't say whose car or who was driving what kind of cars, so she couldn't answer that part. So apparently she can't claim that she was driving behind this person in this complaint, but she does admit she does. She claims she admits that she rear-ended the vehicle in front of her, causing the collision. And then she claims that, so in the lawsuit that was filed against her, the woman claimed that all the other cars stopped, but that Ysabel did not. And she's the one that caused the collision, and she couldn't answer directly if that was true or not. She does admit she caused the collision, though. And she also says that she doesn't have enough information to confirm or deny parts of this, including that she failed to reduce her speed or maintain control of her vehicle. The force of the impact caused a chain reaction collision. The collision was caused by her negligence. And basically, what she says is that she lacks sufficient information or knowledge to form a belief as to the truth of the allegations contained in 18 through 22, and therefore admits the same. And she denies every allegation contained in plaintiff's complaint not hereto admitted or denied. She denies every other aspect of complaint. So every other aspect is that because she drove negligently, she caused the collision, and that the plaintiff suffered injuries, and that it's her fault, and that she incurred injuries of more than 3,000, and she suffered pain and suffering in both of body and mind, and loss of enjoyment of life. And so she's denying that she caused any of that, which I guess when you're being sued, denial is one of the best ways to get out of denying it is a good way to go. It would be difficult in this situation if there's not like a crash investigation, and I don't know if there was, to determine who was at fault. But she also says that she alleges that evidence that may be discovered to indicate that any injury, damage, or loss sustained by plaintiff was proximately caused by acts and omissions of persons for whose conduct this defendant is not liable, and that she demands that any other such party be named on the special verdict form for purposes of fault allocation. So it sounds like the direction they're going to go is that she might have rear-ended one guy, but she didn't cause the other guy to rear-end that guy, to rear-end that guy, to rear-end the woman in front of her. And I'm not sure how it would work if all three cars were stopped, if she hit one, if the force of that one would then cause all of the other cars to move forward if they're all stopped. I don't really know how that works. So I'm not a crash person or an expert. And Ysabel says the conduct of all parties to this action must be compared to determine the degree of fault, if any, among the parties, and damage or loss must be apportioned accordingly. So she's going to argue that even though she rear-ended the person in front of her, the other two cars might have liability here too if they were also moving. And because she doesn't know who caused a collision with the person 4 cars ahead of her, she can only say what she did. And so she's basically asking the court, listen, if other people are involved in this, I need to know. And if anyone else has any fault here, we need to determine that. And they need to split the cost of damages if that's appropriate. And then her other defense is that evidence may be discovered to indicate that she has failed to mitigate damages and injuries, if any. So if she wasn't wearing a seatbelt, if she didn't have a car airbag, if there was something with her driving that caused it or contributed to it, like perhaps she was driving too fast and she wasn't, that woman, paying attention, and she broke too fast, right? So if she broke too fast, and it didn't give anyone else a time to respond, maybe that's the direction they're going to go. She's also saying that defendant alleges that evidence may be discovered to indicate that the plaintiff has received personal injury protection benefits as a result of the motor vehicle accident, giving rise to this action. And the amount of those benefits must be deducted from any recovery herein by plaintiff. So if she had car insurance and any of her car insurance covered it, like say she was injured in the car and the woman having the car had an accident, and then her insurance paid for her hospitalization or paid for her injuries based on a claim she filed to her insurance, she is saying that that should be deducted and she shouldn't have to cover that. It's also curious that she wouldn't go to Ysabel's insurance company. Simply because if she had an insurance company, this would be a dispute between insurance companies and not between two parties that are driving cars. And then defendant reserves the right to assert such additional affirmative defenses applicable, which can be discovered by discovery. She prays for a judgment of no cause of action and for defendant's costs for such further relief as it's just inequitable. So the state of Utah is one of several states in the country that has no fault when it comes to car insurance, meaning that regardless of who's at fault, your own car insurance will pay for your medical expenses and other lost wages up to a certain dollar amount. And in the state of Utah, every single driver is required to cover a minimum of insurance of $3,000 in personal protection, which is what personal injury protection. And personal injury protection in the state of Utah does not cover for like pain and suffering. And it doesn't have like you're not going to get big damages there. What it covers are medical bills, compensation for the accident, lost income, special damages for task and injured persons can't do like household work because of their car accident injuries. If they die, they'll pay for funeral or burial, and compensation to the person's heir if the car crash results in a covered person's death. So you can sue the other person if you have expenses outside of what was covered by your own insurance. And according to nolo.com, in order to step outside of Utah's no-fault car insurance claim system and pursue a claim against the driver who caused your accident, your case must meet certain threshold requirements. So in order for them to pursue a liability claim against the other driver, the injured driver has to first have incurred at least $3,000 in medical bills as a result of the accident. And they also have to meet and have suffered serious injuries. And those kinds of injuries would qualify under a injury threshold, which are permanent disability, permanent impairment, permanent disfigurement, or dismemberment. And if your injuries qualify under one of those, you're not limited to a no-fault claim under your own policy. Then you can hold the driver responsible. And you can file a third-party car insurance claim or a personal injury lawsuit. And then that's where she can get losses for pain and suffering and non-economic damages. So I don't know why she wouldn't just go directly to Ysabel's car insurance company. I mean, maybe she did and that she got denied. I don't know. But because of the way that it's set up in the state of Utah when it comes to the insurance companies, you can't get pain and suffering and other non-monetary damages that have stemmed from the accident. So if you're seeking like a bigger payday, that's when you have to go outside of your insurance and go to the third party. And it's weird though that it's like 2 years later and she's suing her now. And the one thing I thought was weird about the lawsuit in general is that it was really vague. Like, generally speaking, when a lawsuit is filed, it'll say the date of the accident, it'll give you the details, they'll have an attached crash report, or they'll have an attached ticket, something to prove that the person that they're suing is the one that caused the accident. And they didn't say anything like that. They literally didn't attach anything. And she also didn't state what her injury was. Not to say that she's not injured, it's just she didn't say what her injury was. She just said that she suffered bodily injuries, some of which may be permanent. So it sounds like if they're not permanent, and if there's not permanent impairment or permanent disability, she might not even have a claim. So that part of it could be a way for her to get out of it because she obviously could have had injuries, but if they aren't permanent or if they could be permanent, you would kind of know if something's going to be permanent after a couple years, though. I mean, if you had a concussion and you got, a serious head injury, you would know after a couple years if that was going to be permanent. Or if you had a spinal injury or, something seriously injured you, you would know after a couple years if it's going to be permanent. But this say some of which may be permanent. So Ysabel can fight this by asking a court to look at the totality of the situation. She can actually have the court determine if this driver was breaking any laws at the time of the accident as well. So according to the Utah website I was looking at, say that this person was speeding. If she was speeding and she was also breaking the law when the accident occurred, and then she stopped while speeding, and then that wouldn't give enough time for other people behind her to stop at a safe rate, well, Ysabel could be found to not have been at fault. And if there's all these other parties involved, these two other cars, you would think that you would need to figure out, first of all, what the speed of all the cars was, what the crash report says, what the ticket says, and none of which has been provided to the court. So I don't know. It's a very vague complaint. And so I think Ysabel has every right here to defend herself. And in the state of Utah, the threshold is pretty high in order to win in these types of cases. And so just because she says Ysabel is at fault doesn't mean that Ysabel is at fault, right? And just because she says she was injured because of Ysabel doesn't mean she was actually injured because of Ysabel. The world of car accidents is a science I'll never understand, but I know well enough that she should have been going to Ysabel's insurance company instead of going to Ysabel directly. And there's no discussion here about insurance, which I think is weird because both drivers under the law have to cover insurance. And so the claims should be with the insurance companies. And she is not saying that Ysabel was not insured. So if Ysabel's insured, she should be going to Ysabel's insurance company, not to Ysabel directly. So Ysabel might also be able to say that as well. But she's going to fight back. And I think just based on the complaint itself, it looks like she has some room. I'm not a lawyer, but I would say she, it looks a little bit fishy to me because there's so lack of details here about what actually the injury was, what it caused, what occurred. And I always feel like in a complaint, you should provide as much information as possible. And I think that's also why, Ysabel's like, you didn't even state a claim because you didn't tell me what your injury was. You didn't tell me how much you spent at the hospital. You didn't provide me a copy of the accident report. You haven't really told me how this is my fault because I don't even know what happened to you. So how do you say that someone's seriously injured and it's your fault without telling the person these are what my injuries were? So we'll have to see how it all pans out. So I'm glad that she's got a lawyer. I'm glad that she's got good representation, and hopefully everything works out and it's sorted out in the court because these kinds of cases are a nightmare to deal with. And if the person suing her is doing this because they know that Ysabel's on a reality show and it's for money and it's 2 years later, it just seems weird. It just seems like weird timing, honestly. But that's just my opinion. So tell me what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, bestie.